Good morning.
Good morning, Your Honor.
Good morning.
Let's see. Would counsel approach here? I'll just give you a couple minutes to read the instructions I just handed you. Have you had time to read those?
Yes, Your Honor.
Mr. Snedden?
Yes.
Well, I'm sure glad we stopped yesterday. That was exhausting. It's amazing how things look different the next morning, huh? Okay. Number 1. I'm going to take some items up that are hanging loose here. Number 1 is that the special instruction requested by the district attorney read the definition of property as being something of value. I'm going to give that instruction. For your purposes, I'm placing the instruction in the package to the jurors following CALJIC 14.70. Number 2.
And, Your Honor, just so the record is clear, I think we objected to this yesterday, but we definitely objected.
Okay. The record's clear. You definitely object to it.
Alright, thank you.
Number 2. DA's proposed CALJIC 3.30 read general criminal intent. It appears that the DA's proposed 3.30 is adequate, furnishing alcoholic beverage as a lesser included. I'm going to give that and place it after 16.010. That's in the package I. The next one is in the package that I gave you on false imprisonment.
Yes, Your Honor. I don't think we got the 3.30 for furnishing, the one you just referred to. We do have the one on false imprisonment. Maybe I'm wrong on that.
It came down. The district attorney. I had ordered them to prepare it and bring it to my office. And they did. I assumed they would give you a copy of it. Did you give them a copy of it?
Your Honor, I can't tell you that, because Mr. Franklin did all that, and when he left, he went directly back to Santa Barbara. So I guess if they didn't get it, I would assume that he did not do that.
Well, he gave me 3 or 4 instructions yesterday afternoon.
I know he did, because he was called back. But I was not in communication with Mr. Franklin after that. And I know he went back to Santa Barbara.
Why isn't he here today?
Because he has a brief due with the California Supreme Court.
Oh, you got him here as being your representative on instructions, you know.
I got him here to carry my briefcase. But I apologize, Judge, I just didn't know. These are not.
How do I know what one's you?
I think you should assume that whatever Mr. Franklin did for the court and gave extra copies of did not get to Mr. Sanger. I think that would be a fair assumption.
Here's another copy.
I understood there was only 2, perhaps 3.
What's the another one?
The only one that we received, Your Honor, was the property, or something, and something of value, defined.
I know he did 3.31. The mental state one he came back and did. And there was one other that the court requested he come back and do.
I think we got property, and something of value, yesterday. I think he brought this back yesterday before the end of the day while we were still in court. But we did not receive anything else. I don't want to pick on Mr. Franklin. He was, I'm sure, trying to do his best, but we just haven't seen them. So if we could have a copy, I'd appreciate it.
What were the other ones? He did 17.01.
3.31 and 3.31.5, and the property one.
I think it's the mental state one.
Yeah.
And what number was that? Do you know?
I think it's 3.31.5.
So that would be 3.31.5.
Okay.
I know that one for sure. And I think there was one other, which may have been the lesser included, 17.00.
What was the long one we had him filling in all those blanks? Do you remember?
That was 6.23.
And give it to Mr. Sanger and then give it back to me. What was the other one?
6.23.
Okay.
I believe that one was actually delivered to the court and I think Mr. Sanger has a copy of that one.
Yeah.
It was delivered before we left yesterday.
That was delivered yesterday during the day while we were in session, changing the
font.
Changing whether it was capped or not capped. We got the final version of that, so we're okay on that one. Okay, so we now have 3.30 on the furnishing, misdemeanor. And I think the court's ruled that comes in. And we have 3.31.5 on mental states, and we will submit on that. And then we have the property, and something of value, which we got yesterday, to which we objected and the court accepted it. And then we have 6.23, which changed the capitalization. So are there any others that we're missing?
Probably, but I don't know. I have a feeling there's one more, and I'm trying to remember which one it was.
I heard somebody say 17 something.
I said that.
17.12.
I'm thinking of the one that had all of the blanks in it that we asked them to prepare. Maybe Tracy remembers.
That was, I think, 17.12.
17.12.
That's my recollection. It was something in the 17.00 series, and I think that's the one.
And they did do it, and I think the copy was in the packet that you handed out, the copy of what the DA prepared.
You got that copy?
You gave us that this morning, 17.12.
Okay, what I want you to do, then, is come up and get these. There's two more here. These are minor changes. On that, I just changed the heading. I took the heading off. I'll show you this is what it said before.
Yes.
Okay.
Then the next one. I gave you a proposed C, and now I'm giving you a different proposed C, and the only difference is in this line here. Identified as People's Exhibit 910, instead of, as an addendum, which it previously said.
Very well, thank you.
That's in the package I gave you this morning.
And we do want to be heard on that.
We're going to go through all this. We were starting to go through all of this.
All right.
All right, the next thing. We had just finished discussing 3.30 on the furnishing alcoholic beverage lesser, and I told you I would put it behind, well, following CALJIC 16.010. The next one is the instruction as it relates to false imprisonment.
Yes. Could I be heard on that, Your Honor?
Yes.
I'll stand up so I get a little exercise here this morning. I have a suggestion on that one that I think will help, and we'll see. I would propose that there be a second paragraph added to that says, however, before a person can be convicted of conspiracy to commit false imprisonment, the specific intents to commit conspiracy must be proved. And I think I could have made it more elaborate, but I think that would help the jury not to get confused when they're being told, specific intent, and then all of a sudden, general, on one of the conspiracy counts. And I wrote it out, if the court would like to have what I just read.
Okay.
Mr. Snedden?
Do you have it? This is that area it's a difficult area. So that repeats another instruction. But I don't see any problem with giving it at that point, because it is a tricky area.
I don't have a problem with that, Judge.
May I approach, or just?
Would you just give it to?
Thank you.
I think if you send that over to Carrie.
I'll take it.
Then the, number 3, 17.12, as it has been prepared, seems, this is the one that the district attorney. It's a standard CALJIC instruction. But there were a lot of blanks in it, so I had them fill in the blanks for us. It looks all right to me. Have you looked at it?
I have looked at it. Obviously I haven't compared every word, but it looks correct.
Okay.
However, could I just briefly be heard?
Yes.
On that, I don't want to. It seems the court is committed to giving the lessers, but having done a little more research on it last night, it does appear that the standard would be that you cannot commit the greater without committing the lesser. And the greater involves anyone. The lesser involves a minor. So you can commit the greater without committing the lesser. And of course there's the issue of furnishing versus administering. I believe that Mr. Snedden yesterday, and I don't know if he actually said it loud enough to be on the record, but said something to the effect that if it's substantially the same, it's acceptable. And whether he said it on the record or not, that seems to be the Geiger standard for lesser relateds.
You mean you listen to what he whispers to his colleagues?
He wasn't whispering. It was, at the very least, a stage whisper, if it wasn't said loud enough for the record. I don't know if it got on, but I couldn't help but hear it. The point being, whether the court heard it or not, the point being the Geiger case was overruled. That was the lesser related standard. And that was only at the request of the defense. So I'm not going to argue it further. I think the court has in mind what the law is, but I do think that it would be incorrect to let in the lesser. I realize that would result in some revision of jury instructions at the last second, but
Well, that's not the issue. But, we're here. As you see, we're changing jury instructions as we speak. So it's not a hardship on the court to change the language in a jury instruction.
especially if you're deleting some of them. I suppose that would be a good thing.
Well, getting to the point, there's two mandatory, I'm sure you've read this mandatory criminal jury instruction handbook. And on page 3, D 1.7, lesser offenses to offense charged, there's two approaches that you have to look at. One is the legal elements test, which you've been discussing, and the other one is the accusatory pleading test. And when you look at the language in the indictment, you find that the accusatory pleading test, if you follow that, is the test that mandates that I give the lesser included.
I think that would answer the second part, which is minor versus anyone, because the accusatory pleading would give notice of a minor.
Right.
And I think that's what the court's referring to. But the furnishing versus administering, I think, is still an issue.
It seems that you would have to furnish to administer, or, it doesn't seem, to me, to be a.
There's.
Anyway, yes, I've decided to give the lesser included.
Okay.
And here's the changed 330, 3.30.
I'll bring it back if you want.
And that should go in the material. What's the number of the instruction on false imprisonment?
9.70?
Yeah, here it is, 9.60. 9. So I'm going to put it right behind 9.60. Then I do not have a clean copy of 17.12. Does someone have a?
Yes, Carrie does.
Okay, I need that.
All right.
Number 4. Let's see, we covered that. The furnishing alcohol to a minor. Number 5. The court's proposed instruction C and C1 on the various use of the videos. What I'm proposing to do here is to instruct with the court's proposed C and put that after 2.09, evidence limited as to purpose. The thing that's, and I did receive your points and authorities this morning. And I agree with your points and authorities on use of the outtake language. It's clear that. That's why I admitted the outtake footage was to give a complete context of everything that was said. But the case you cited doesn't stand for admitting it for the truth of the matter asserted. I think it stands for what we thought, is that you admit that for what other purpose you admitted the main body of material. So it's a good citation, but it doesn't change my approach. My approach is outlined in Instruction C.
I do have a comment on that whenever the court's ready.
Yes. Before you comment, let me explain something so you get. Maybe you have the complete picture. Maybe not, but I want to be sure you do. So, initially I'm beginning to think like you. I was going to explain all of the side stuff before I got to the point. It's time we end this, I'm going to go to using an exhibit, which I've marked as People's 910, and that contains the material that they prepared at my request, which is the material that they are going to maintain to the jury as an admission. And by using an exhibit of the people, I had originally placed it as an appendix to the instruction, but I think that makes the connection to the court that I don't want to make, that it's not me that's proposing that these are admissions. I have to make some preliminary determination, but not final, and I don't think they need to know that I have to make some preliminary determination. So the DA needs to say, these are, in his argument, he'll say, these are things that we urge you to believe are admissions by the defendant. Then I have, the exhibit as referenced, so that the jury can, if they choose to, look at it, or if the DA chooses to, can show the jury this exhibit, which is the admissions you are claiming. But at any rate, they have something specific to relate this instruction to. And on instruction C1, it's really the standard admission instruction, but I have pinpointed it to, with the paragraph in the middle that refers them to Exhibit 910, and then reiterates again that they are the exclusive judges as to whether or not there are admissions. So that's my proposal for covering the admission part of this video. Now you may speak.
At my peril, evidently, but I will. On Exhibit C, first of all, I would propose to modify it in paragraph 4 that says, the outtakes video. If you go to the second sentence, let me tell the court what I propose to modify and then explain why.
Yes.
I propose to say, instead of, none of, take that out and say, the statements in the outtakes video may be considered for their truth, and then strike the rest of it and say, if they are on the same subject matter as the statements offered by the people in Exhibit 910. And conveniently, your modification to put the reference to Exhibit 910 in the very latest version makes that work conveniently. Now, having said that, the argument is.
Just a moment. Let me make sure I understand that.
I can say it again, if that helps.
Well, I'm reading it. Okay, so the proposal is, instead of, none of, it will say. It will start out with, the statements in the outtakes video may be considered for their truth. I see. It's covering. There's actually. I've taken a sentence that was covering another subject, which is that in any of, either the outtake or the Bashir video, if the same, they show the same scenes. Some of the scenes are the same. Some of the outtakes are the parts that the Bashir video uses, so the words are the same. So to the extent that those are the same words in both videos, if those, then that's what that sentence is meant to say, that they would be admitted for the truth of the matter asserted, if they're on this list. Now you want to cover the second problem, which is, what parts of my statement that I want to introduce can be taken for the truth of the matter asserted?
That's correct. And I think, given Evidence Code section 356 that says, on the same subject, so we've taken the same language there, if they are on the same subject as the statements offered by the people in 910. Now, I understood, from the court's comments earlier, that the court apparently is not reading 356 to say that statements on the same subject come in for the truth of the matter. In the Douglas case that we cited, where it says,
no, they would be. You're not understanding what I said. 356 and the Douglas case do not stand for the proposition that if I admit statements not for the truth of the matter asserted, and you want to connect statements to that they get to go in for the truth of the matter asserted.
Okay.
You are not maintaining that.
I would agree with what the court said. I'm talking about the statements in Exhibit 910. So if.
Okay, so I'm not saying what you thought, what you accused me of saying.
Alright, good.
Alright, so the issue is, I agree with you that if part of the admission is not given, if the part of the statement, the context of the statement is not given by the district attorney and there's more to that statement, then that should be considered for the truth of the matter asserted also as part of the statement. If there's an admission there and it comes in for the truth of the matter asserted, then any part of that statement that was excluded by the DA should also come in with the same understanding.
If it's on the same subject matter.
If it's part of that statement. See, what?
The way I look at it, I understand what the court's saying.
Here's the problem that I see with your position, is that there's a whole lot of discussion about children by Mr. Jackson. And if the subject matter you're saying is children, then my answer to you is no, that's too broad of a subject matter.
Well, okay, and I understand that's the answer. If that's the ruling, I won't argue with it, but if you're inviting discussion on it.
I'm inviting discussion.
It seems to me this comes up all the time, and you'll have typically a letter or a writing or a statement made to the police by a defendant. Somebody's arrested, they're given the Miranda rights, and they sit down and they talk about the case, and the prosecution comes in and says, we want to take this statement and we want to say that's an admission. You're allowed to play the entire tape and the jury's entitled to consider the entire tape. It happens all the time. The entire tape of the police interview. And they can consider it for the truth of the matter asserted. Now, I suppose, and I must say, I can't remember anybody ever doing this, but I suppose it could happen that there could be a discussion on the tape about something that's totally irrelevant, and the prosecution could say, well, you can't have that, because they're talking about, another event or something totally unrelated to the case, but otherwise the whole tape comes in, and it happens all the time. Same thing with a letter. The whole letter comes in as long as it's the same subject matter. And so what you have here is you have a series of tapings and interviews by Bashir that take place during the latter part of 2002, on into the early part of 2003, in January 2003, and Bashir clips from these various interviews snippets that he puts into his production. Some of those actual conversations Mr. Mosley did not have, he wasn't there, nor did he have a camera running to tape record the rest of what was said during that period of time. We're stuck with what Mr. Bashir has pulled out to put in his video. However, the rest of it is one big ongoing conversation with Michael Jackson, and he does take clips from the other tapes. So I believe that, and I'm disagreeing with the court directly, but I believe that anything that's in 910 that is put in context or involves the same subject matter that's on these tapes is fair game for the jury. Now,
And the Bashir tape should come in for the truth of the matter asserted because it's all on the same subject matter.
well, no, actually there's an argument. There would be an argument by the district attorney that anything that Michael Jackson said on the same subject matter on that tape could come in. And I think that that's true. If Michael Jackson said it on the Bashir tape, and it pertained to the subject matter of children, it could be considered. I think that that's basically I suppose you could put a sentence into that effect as well. And it really takes us back. I hate to say, but it does take us back to the initial approach where I suggested that on both the Bashir tape and the outtakes, that any statements, I don't have it in front of me here, but I provided in writing, any statements by Mr. Jackson on the subject matter of his relationship with children can be considered by the jury for the purpose of determining whether or not it's an admission, and it can be considered for the context of any such alleged admissions. See, if we try to parse it, I do agree with the court.
I understand your argument.
I do agree with the court that the other statements by Mr. Jackson would come in, but not the whole Bashir tape.
All right, do you want to be heard, Mr. Snedden, on this?
Only if the court's going to entertain this change, because I think it substantially changes the situation that we all operated on from the very first day that this trial started. I believe Mr. Sanger is wrong. I believe the court's analysis is correct, and I think the instruction correctly states the state of the law and the state of the evidence in this case and should be given just as you proposed it.
I'm going to give it as I proposed it, with this caveat, and I've invited you to do this before. If there is specific, that's why, by the way, I asked him in the beginning to provide us with the statements that he asserted were admissions, was so that you could look at those areas and see if you wanted to show me, and then the jury, wait a minute, he's taken this out of context. What was being discussed at that moment? Here's the whole discussion at that moment, at that minute, not at that day or hour or, So I feel I've given you the opportunity to do that. And that was specifically the reason
As I indicated yesterday, we had marked the transcripts of the outtakes to show the portions that we believe are. But I'll tell the court in advance, they are substantial. So if the court's saying limit it to the minute.
Yeah, it's the same thing you're saying, and that's not what I'm willing to accept. I know you're not missing my point.
Okay.
Judge, I was just going to make a comment about that. It's my recollection, and Mr. Sanger and I disagree on this, but you have the transcript. It's my recollection that the outtakes end before the substantial part of the discussion that are the subject of what would be People's Exhibit.
I know you asserted that before, and I don't have to make that determination because it's up to Mr. Sanger to bring up those points and, if he wants to bring them to my attention, to do so.
Okay.
So with your noted objection and reasoned argument, I will go ahead and give instruction no. C and C1, and I'm going to put the limiting instruction after 2.09 in the total package. And then 17.12.
Your Honor, where did you say C and C1 go, if you recall?
It goes after 2.09.
All right, thank you.
And did I tell you I placed 17.12 in front of 16.010? Now, the next item will be should 17.01 be given when you consider 4.71.5 and 17.02?
Your Honor, what was the first one, for what?
4.71.5. 17.02 says, each count charges a distinct crime. You must decide each count separately. 17.01 says, the defendant is accused of having committed the crime of lewd act upon a child under 14 in counts 2 through 5, and then it goes on with the others. The prosecution has introduced evidence for the purpose of showing that there is more than one act upon which a conviction may be based. So I'm asking you, do you need both of those instructions?
Well, 17.02 does not cover the subject matter in 17.01. And I'm looking at 4.71.5, and the problem with 17. I'm sorry. The problem with 4.71.5 is that that's really related to a time period.
Aha.
And it's not related to the actual proof of the particular acts, and I think 17.01 does in fact address
Different.
the issue. Now, we submitted special number 3, which the court was thinking about giving, and then, which attempted to cover the same issue.
Aha.
And I think that issue has to be covered directly. 17.01 seems to be a more direct instruction on that subject matter. I don't think the others really address it. The only thing I'd add is I think count 6 has to be in there, too, because even the court had to ask the prosecutor, what was your contention as to count 6?
Well, I guess the question I would have is, to the district attorney is, under 17.01, we have counts 2 through 5, lewd acts, and counts 7 through 10, administering an intoxicating agent. And then we say that all jurors must agree upon the same act or acts, which is what was covered in number 3 special, somewhat, that Mr. Sanger submitted. And I guess I would ask the district attorney, what are the acts in counts 2 through 5 that you're depending on, if you care to tell me?
Well, sure.
And, okay.
I mean, I don't think there's any mystery as to this. The 2 of the counts are the incidents as viewed by Star Arvizo.
Right.
And the other 2 counts are the 2 counts that were testified to by Gavin Arvizo.
I agree. That's what I don't think there's a mystery about that either. But which one is on which count?
As to which count? Well, that's
the mystery.
Well, it's not a mystery, but it's not delineated, that's correct. In reading the use notes under 17.01, it does look that 17.01 is directed to those situations where there is a singular count but multiple acts upon which the jury could derive a verdict of guilty on the singular count. I think that's somewhat different than the situation that we have here.
I don't think so.
Well, I was going to say, I don't see a particular problem in giving both, if the court wants to give both.
The reason I don't think it's different is as to each count there are multiple acts that could be attributed to that count.
Because they're not delineated.
Because they're not delineated.
Alright, I think that's correct. I think perhaps, yeah. I mean, I don't have a problem with giving the instruction. I just think that our problem with the special given by the defense was the particular set of facts, and I indicated to the court yesterday where I saw that to be a problem. So.
Well, their language isn't much different, when you look at it, than 17.01. All jurors must agree that he committed the same act or acts.
To me, that's substantially different than a particular set of acts, but it encompasses it encompasses more than the commission of the crime as defined by the court. And to me, that's substantially different, and particularly it eliminates the mischief that can be made from arguing the kind of thing that I pointed out to the court. So if you're asking me whether I think we should give 17.01, I see no problem in giving both of them.
I guess I'm asking you one thing further, and that is, are you going to tell the jury that count 2 is when Star saw him the first time, count 3 is when Star saw him the second time, and count 4 is when Gavin said he was first touched, and count 5 is when he was, I don't want to.
Let me put it this way, Your Honor. I don't think we specifically intended to do that in relating one to the other, only because they're not mentioned. However, if the court is inviting us to make that election, and there's no objection from the defense, we have no problem doing that. I just think to do that in the middle of the argument, without prior approval of the court or counsel for the defense, would be not right. But if you're asking me to make an election, that's a very simple thing for us to do, and if counsel for the defense wants us to do that, and I believe it would probably help the jury in their deliberations, I'm more than glad to make that election right now.
And
you can put that in the verdict forms if you wanted.
And the same would be true on the count 7 through 10.
On the alcohol.
The alcohol.
Yes, sir.
Do you wish to be heard, Mr. Sanger?
Yes. That is a point I wanted to raise before we are through, so, I think the election should be made, and the problem we have is there is a good instruction, 6.23, on conspiracy that lays out exactly what the charges are there, and then there's really nothing else. There's the introductory, well, it's one. I don't have the number right here, but it's one of the first few where you talk about what the charges are, and they just list the charge by name. And then when you have the actual substantive charges on lewd act, 10.41, for instance, and the other substance, it simply says the defendant's charged. Nothing ties it to particular acts.
But if we make him accept his
Offer.
offer to make an election, then, and to tell the jury in his argument the election, then I think that takes care of that problem.
I think that would take care of it. The other way to do it would be to instruct on it, or.
I think because we're pushing this, I think I'll go with the election.
We want to make sure we know exactly what the election is.
He's going to do that right now.
Okay.
And then we can discuss. He is willing to have it as a finding in the verdict also. Would you like that?
I'd have to see what it looks like. I get concerned about verdicts being too factual.
We can discuss that, and it doesn't have to be in the argument.
That's correct.
All right, would you make your election and?
Count 2 would be as to Gavin Arvizo. Count 3 would be as to Gavin Arvizo. Count 4 would be the same victim, but the observations made by Star Arvizo. And Count 5 would be the same victim, but the observations made by Star Arvizo. With regard to the intoxicating, the violations of 222, they would just mirror them. So the first two would be as to, the first two would be as to those incidents, as to Count 2 and to Count 3, and the last two would be as to Count 4 and to Count 5.
Can you define the two? Now you've got it down to two. You still have an ambiguity. Is there something you can say further to select that Count 2 is as to Arvizo? As to Gavin is this, and Count 3 is that? Is there some language?
First in time and second in time.
First in time, second in time?
I would not be willing to go that way. Because I don't think there's any. The state of the evidence at this particular point is open to the jury to make that decision on their own basis.
But if they decide?
I don't think that's why we alleged.
That's not that clear. Is that what you're saying?
I'm saying the jury has the option. His statement over and over again has been it was towards the end, and so I'm not prepared to say that one was before the other, and I don't think we even have to. And I am willing to say that, the first two were based upon, solely upon, or based upon the testimony of Gavin Arvizo, and the last two were based upon the testimony of Star Arvizo. And I think that makes it very clear for the jury during that time period that that's exactly what we're talking about.
Okay.
And
will you have the person arguing your case
state that
at some point in their argument?
Yes, sir. I think it's also important, however, at some point in either in the verdict forms or in the instructions that also come from the court.
Before we get to that, go ahead.
And I really feel that it ought to be in the verdict forms. I really feel that if we're going to make this kind of election and we're going to tell this jury, this count applies to this and this count applies to this, that to simply have somebody get up and state in final argument, this is our election, doesn't help the jury.
You don't have to say it's your election. You can say, this is what we're maintaining.
I understand that, but what I'm saying is, I think the jury needs the direction that is, in fact, what the verdict forms reflect.
I do have a suggestion on this when we get.
Yes.
I don't want to cut off Mr. Snedden.
Yes. Let me hear your suggestion.
My suggestion, first of all, is if you take 1.06, that's where it's the identification of the parties in the crimes charged, and we use that instruction to simply add some language after the description of the crime charged. In other words, it says, lewd act upon a child, and you can say, to wit, if you want to be archaic about it, but something to that effect, and then indicate in brief form what Mr. Snedden said. Now, I do have a problem with the concept that the jury can pick and choose even between the two sets of, or within the two sets of charges. So I want to be heard on that.
No, go ahead now.
Just procedurally. First of all, I think we can add the words right there in that 1.06 and that should clarify for the jury entirely. They have 6.23 to clarify the conspiracy, and then they would have this to clarify the rest. Now, on the substantive part, I don't believe that, consistent with the case law that we've been discussing, that the prosecution can say, well, we have 2 or more acts, and they could have occurred, and we don't know which one is which. And if the prosecution can't even tell the jury which one is which, the jury certainly can't discharge its duties, under Blakely, to determine beyond a reasonable doubt whether or not a person is guilty of that offense. So if we're going to honor the commitment which I think is reflected in 17.01, that the jury has to actually decide on an act or acts for a particular count, somebody's got to delineate what those acts are. And it's not close enough to say, well, there are 2 things that Gavin may have testified to, 2 or more, and there's 2 or more that Starr may have testified to seeing, and that's close enough for government work. I think we have to make it very clear. My recollection of the testimony was that there was an effort on the part of the prosecution to bring out from Gavin that there was a first instance and a second instance. He was vague about it. Clearly, I'm clear in my recollection with regard to Starr's testimony, that he testified there was a first instance and a second instance. So I don't see why the prosecution should not be held to that. I mean, the jury can't simply say, well, we kind of think something may have happened on some day or another. That's exactly what the problem is that we're addressing.
What was the language?
I think my remarks were misconstrued.
What was the language that you thought you could add in 1.06 that?
I would say, for instance, if you go down 1.06 where it says, in count 2, the crime alleged is lewd act upon a child, and then I said, to wit, but you could say instead, the act alleged is the first act alleged to have occurred in the testimony of Gavin Arvizo. I think we have to also say Gavin Arvizo is the alleged victim. And then count 3 would be the second act alleged in the testimony of Gavin Arvizo. 4 would be the first act alleged in the testimony of Starr Arvizo regarding Gavin, or however the court wants to put it. I'm trying to keep it short.
I understand. That's right.
And then 6 should also be identified as the attempt. The court asked about it should be at least the attempt alleged with regard to Gavin Arvizo. And then 7, 8, 9 and 10 would be the same language.
Okay, what did you want to say, Mr. Snedden?
I have no problem with that. That's what I was telling the court.
Okay.
I have no problem making an election. In fact, if you want to be more specific about it, you can say, with regard to Starr Arvizo, that the first incident involves the one where the doors were locked, and the second one involves the incident where the door was closed but not locked. I wasn't trying to not be definitive. I mean, we made an election. There's no secret here about what happened, and I think I was misconstrued, what I was offering to do for the court. Seems like the more I offer, the worse it gets for me, so I'm willing to do that.
I misunderstood what you were saying.
Well.
And I don't think it's getting worse for you.
Well, okay, I'll just let it go.
I think we're working out a problem that exists in all of these cases. I've never had a case involving a child molestation allegation that didn't involve the same problem. The children don't give dates and times, and you work with a difficult scenario of trying to determine when these things happened and to plead those items in a good way, a way that's productive. So I sympathize with the problems the prosecution has. And I think your agreement to elect is very helpful to the court. It would be very helpful to the jury.
I agree.
And, I just don't see this as a bad thing for anybody.
Maybe what the court could do.
I was thinking of taking the break.
Maybe what the court could do is take a break.
But before you do, what was your last suggestion?
I was just thinking that the way to word this might be, in count 2, the crime alleged is lewd act upon Gavin Arvizo, so you don't have to repeat it.
Yeah.
And then say, alleged in the testimony, the first event alleged in the testimony of Gavin Arvizo, words to that effect.
Well, I think I would go with the language the DA is suggesting, so that, the first, is still a vague statement in terms of the child's testimony, I think.
There are 2.
If he wants to identify, put some identifying factor. The door is locked, the door is unlocked. That's something that clarifies each issue is fine with me.
He could do that in argument.
He could.
And I was just trying to think of a generic way to address it, because these are the court's instructions, obviously.
Right.
And rather than have the court talk about too many facts, because you have to keep saying, alleged, 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 otherwise it has the impression.
If you're satisfied with just identifying that Gavin is the first two are Gavin's testimony and the second two are stars, and the district attorney delineating which those acts are in argument, I'm satisfied with that.
Okay, well, I still think it should be some delineation like the first and the second. I thought.
If the DA opposes that, and I understand why he opposes that, so considering that that's not going to work, are you satisfied with the way I've presented it just now?
Well, then, no. Because I think we do have to distinguish. The problem is we have to distinguish between count 2 and count 3. And I understand the district attorney's saying he's going to argue it that way, but I think there should be something in the allegations so that the jury can look at it and say, this is what we're asked to decide.
All right, we'll take a break. Okay.
May I address the court on that issue?
Yes.
Well, let me get to the point, Your Honor. I'm right. How's that?
Good. We got all of that.
Here's why I'm right. If you look at counts 2, 3, 4 and 5 in the indictment, they specifically refer to the first and second incident testified to by the witness. The first two say testified to by the witness. It says, John Doe, but that referred to Gavin Arvizo. And 4 and 5 refer to the first and second incidents testified to by Star Arvizo. So I think the election has been made in the indictment, and that's what he was indicted on. I think the jury's entitled to be told that there's just that. If you look at, actually, the count 2 does not say, first, but count 3 says, the second molestation concerning which John Doe testified. And then count 4 says, the first witnessed by James Doe. And count 5 says, the second witnessed by James Doe. So it's been delineated that way, and what I'd suggest the court do, because I think the defendant's entitled to have this kind of certainty. That's what he was indicted on. That's what
I think you have a very good point. Mr. Snedden, do you want to say anything about that? It seems like we could just take the language from the indictment and attach it to the counts, and that's pretty close to what you were saying anyway. Do you have the indictment?
I do, and I'm reading it, and either I have a different copy of the indictment than Mr. Sanger does or the court, but my indictment. I was not present when the indictment was returned, and
It does. It does say that.
well, that's what I said. They must have given me a different copy than the copy.
Would you like to approach and look at?
It's up to you. I've got it. This is a copy.
The copy that Mr. Sanger is showing me is not the copy that I have.
Okay.
So it is not, I have special findings as to the conspiracy, but my copy has no special findings as to allegations. But if that is what the court has, and if those elections have already been made, I don't have a problem with them.
Okay. That's what I have, and
Okay. And that's the indictment that's filed with the court?
yes, this is.
All right.
This is filed April 21st, 2004.
Then that should take care of the problem.
I just had this printed off this morning so I could deal with the lesser included issue.
All right.
One way to handle it, to keep the number of words down to a minimum, would be to indicate in the paragraph that immediately precedes the list of count 2, 3, 4, 5, where it starts, the accusatory pleading also alleged the following crimes to have been committed by the defendant, and then put, against Gavin Arvizo, or some words to that effect, so you don't have to say he's the alleged victim in all.
That's a good point. Yes, let's do it that way. And then as to each one, you just use the indictment language.
So simply say, I think, to economize on words, the first alleged incident testified to by Gavin Arvizo, and then the same language, the second, and then count 4 would be, the first alleged incident testified to by Star Arvizo, and, the second.
Okay, that's what we'll do. Now, on.
As to 7 through 10.
7 through 10 is the same language there?
That should be. My understanding is those mirror the other counts, so it would be the same language, I would take it.
Is that? I agree.
Nods head up and down.
Yeah, okay. Same language.
And do you want that language spelled out, or would it be enough to refer to, as described in count 2, as described in count 3?
Yeah, I think that would be fine.
I think that would be good, yes.
And then on 17.01, you suggested that we should add count 6, the attempt, the language in there. Is that right?
Yes, Your Honor.
So, did you get that, Jed?
I'm sorry?
17.01. We're going to add the count 6 language, a sentence involving count 6.
All right.
Between.
Well, if we have these identified, we could actually use 17.02.
Just use 17.02?
That's what I think. I don't think you should be using 17.01.
All right, then we don't need 17.01?
I still think we need 17.01. Let me look at 17.02 again, but I don't think it covers the same subject matter. 17.01 makes it clear.
Yeah, I agree with Mr. Sanger. We need both. So put in the language on 6. Just a sentence after, the same sentence after. Okay, now what I propose to do is give you my rulings on your specials. I really think I've taken care of all of the problems and issues that you raised through your specials, and what I want to do is give you my rulings and then we need to get these instructions printed so that when the jury comes in, I can give them all copies.
One housekeeping matter.
Yes.
If the court is inclined to do it, based on prior experience, it would be very nice if the pages could be numbered.
I'm not able to do that at this point. We've pushed ourselves to the limit here, so I'm going to take my package to be printed, with my greasy prints on them and everything.
I was thinking maybe a handwritten number on the bottom. It's up to the court.
Well, if we can do it, I will. I've got staff standing by ready to make these copies, and it's going to take a while. The defense has submitted special instructions, and basically I'm telling you that I considered all of those in revamping the instructions that we've all gone through up until today. Up until now, today. But for the record, I reject special instruction number 1, because it's incorporated in the court's instruction C and C1. I will reject number 2. I've already made a ruling on that. The next one, number 3, I reject that, because I now believe that it's covered by 17.01 and 4.71.5. Special instruction number 4 I reject, as it is adequately covered by CALJIC 2.50.01. On special instruction number 6, this is the one about the sheriff's interview of Gavin, is adequately covered by the court's proposed, or the court's instruction C on special instruction number 7 re Janet's assertion of the Fifth Amendment. I am using CALJIC 2.25, and your proposal is contrary to that. So I reject your special instruction and I will give CALJIC 2.25. As to special instruction number 8 re-evidence of Janet's purported welfare fraud, I reject, because that is covered under both CALJIC 2.20 and 2.23.1. The effect of using number 8, if I did, which I reject, would be to put an undue emphasis on this evidence. Special instruction number 9, the court. This is the instruction considering Miss Montgomery's grant of immunity. This is adequately covered by CALJIC 2.20 and 2.23.1. Again, I reject this because it puts an undue emphasis on this evidence. Special instruction number 10, which was a request to have the jury not consider the invocation of the attorney-client privilege by Garrigus. I reject that because CALJIC 2.26 is a better instruction and does not unduly emphasize that evidence. And finally, special instruction number 11 instructs, is concerning possible discussion by witnesses of their testimony out of court. And I think that 2.20 instructs the jury to take into account the attitude of the witness toward this action or towards the giving of testimony, and I therefore refuse number 11. Those are my rulings, and we will now recess, print the instructions, and if the attorneys will stand by, be available, let's say at 11:15, We have to get you copies and get a final look at what we've got.
Are you deferring, for now, the motion that we filed on the comment during argument?
Oh.
I mean, we can take it up after you instruct, when the jury's done. We're probably going to have time.
That's a good thing, because I need to get these instructions.
That's what I figured.
I was going to say, I can make it easy. The motion we're talking about is the limitation on the instruction on arguing why.
Yeah.
The defendant did not take the stand. And I don't think we disagree that it's inappropriate to give specific reasons.
All right.
I don't think we disagree with that, and that could be handled by an objection. It's been briefed.
All right.
I'm trying to avoid that objection, so.
I don't think it's going to happen, is what I'm saying.
All right.
Okay, I'll let you get.
There's an agreement that your statement of the law is correct, and I will confirm and they agree, and if something happens, object.
Sounds good.
Thank you.
I'm sorry, we're back. We can be off the record, but we're back at 11:15 to get the instructions, and the jury's coming in at 10 minutes of 12 o'clock.
Yes.
Okay, thank you.
And if I need something, I'll call you if something comes up, but I think we're ready to go.
We're right here. We'll be available.